Ms. Chan Yun-han. All right, you are also a member of this BC. All right, we have a quorum. This is the appointed time. So, members, this is the Bills Committee on the Hong Kong Arts Development Council Amendment Bill 2013. And first of all, we need to elect a chairman in accordance with the Rules of Procedure 77, and I'd like to remind members that according to Sub-Rule 6 of Rule 77 of the ROP, if a member so let's begin with the first item on the agenda. That's election of chairman according to the procedures for election of chairman in accordance with the House Rules 21E. I now invite members to make nominations. Mr. Kwok-him from Mr. Yu Si-wing, seconded by Mr. Christopher Cheung and Mr. Leung Chi-chung. Mr. Kwok-him, do you accept? Yes, I do. Any second on nomination? No. So, Mr. Kwok-him, would you please come over to take my seat? Thank you, members. So, on to the agenda proper. Do we need a deputy chairman for this Bills Committee? No? No need? All right, so be it. Then, next item, meeting with the administration. So I now invite representatives of the administration to enter this conference room. And as we all know, this bill is very short. It has to do with policy, I guess. So in accordance with our practice, I will invite the administration in, and then on the bill, I will invite them to brief us on the bill. Yes, Mr. Ho. Yes, this amendment bill is very simple, and this should have been done a long time ago, and we're here to do it. But I also note that the administration also conducted a consultation in 2011, and I think we should hold a public hearing and invite the sector to come and express their views. So I would like to have a public hearing. Oh, on this arrangement, I think I'll wait for the administration to brief us on the bill before we move on to discuss this issue. And public hearing, as far as the Bills Committee is concerned, is a necessity. Chairman, I just make this suggestion first because I need to go over to the other room for another meeting. Today we have with us from the administration Mrs. Avia Lai, Deputy Secretary for Home Affairs, and Ms. Mak Chi Ling, and also Senior Law Draftsman Ms. Cheng Yut-hwa. So good morning, Ms. Betty Cheung. So I'll invite Deputy Secretary to take us through the bill. Over to you. Thank you, Chairman. We tabled into the Legislative Council this Hong Kong Arts Development Council Amendment Bill 2013, which seeks to amend the ordinance, including that specifying arts worker may be appointed by the Chief Executive for nomination, and the we also removed the restriction on cross-arts interest nomination for membership of HKADC. The HKADC was established in 1995 to promote the development of arts in Hong Kong, and according to the ordinance, up to 10 members may be nominated for appointment by the Chief Executive, specified by the Chief Executive in the Gazette, and they are to be nominated by organizations or groups of organizations, and each of these organizations or groups of organizations should be representative of one or more of the 10 arts interests, namely literary arts, music, dance, drama, visual arts, film arts, arts administration, arts education, arts criticism, and Chinese opera. In 1995, the arts sector had the first nomination exercise. At that time, the arts groups followed the guidelines in nominating their own respective representatives. And starting from 1997, the government assisted the arts sector in the nomination exercises. And over the years, the administration has heeded the views of the sector in improving the nomination exercise and have announced the administrative arrangements in this regard. And since 1997, at the same time as the Chief Executive published by notice in the Gazette specified arts organizations, both organizations and individual art workers can be specified by notice in Gazette for nominating representatives, and individual arts workers can register themselves with the HKDC for the nomination exercise. The purpose of the amendment is to specify that the Chief Executive can, by way of notice in the Gazette, specified individual art workers to take part in the nomination process. And since 1999, the practice of cross-arts interest nomination has been implemented by the administration, under which each voter may cast votes in other arts interests apart from its own arts interest. The purpose is to have a holistic view on the arts development in Hong Kong, and very often at present, many of the arts activities involves more than one arts interest, and the nomination exercise in relation to cross-arts interest nomination has been introduced since 1999, and the views of the sector were consulted, and there was general support for retaining the cross-arts interest nomination. So we're minded to amend the ordinance to remove the restriction on cross-arts interest nomination. And on the 18th of January, we briefed members of the Legislative Panel on Home Affairs for the nomination exercise to be held this year in 2013, and the result of the change in administrative arrangement. We have also informed the panel of our plan to make the proposed legislative amendment. The deadline is in December this year as far as the nomination exercise is concerned, and for the administrative arrangements for the nomination exercise in 2013, the amendment is in place, and by the middle of this year or in September, we're going to commence the nomination exercise. We welcome views from members. Thank you, Deputy Secretary. All right, the administration has taken us through the bill, so we understand the objective of the amendment bill. That is to do with policy issues. That's the changes made to eligible candidates for the nomination exercise. Now, the bill itself is very simple. I think our discussion will be focusing on policy. So, views from members on the change, please put them forward if you think that the administration should clarify any matter. So let's start with this direction, and we'll see how things go. And Ms. Sit Ho just now mentioned that the public hearing should be held to seek views from stakeholders. And I checked with the clerk just now, and there is an available time slot on the 10th of June, 4:30 p.m. So, members available for this time slot, Ms. Chen? And what day of the week is that, 10th of June? Monday. 10th of June in the afternoon, you mean? Oh, I have a problem. You have ITBP and also the panel on education. Any other time slots? I'll check. We are going to clash with some meetings, I guess. What about 13th? That's the slot provided by the clerk. That's a Thursday in the morning, 8:30. Is that okay? This slot, is it okay? So tentatively, we'll use this slot, and we will further circulate the other available time slots for members' reference. So tentatively, the public hearing will be held on the 13th of June, a Thursday, 8:30 a.m. So let's move on to the discussion on the bill. Ms. Chen Yuhan? I'm sorry, going back to the previous topic. Are we talking about the time slot on the 13th of June, Thursday, 8:30 a.m.? All right, very good. Yes, it will be around 2 hours hearing. Yes, Ms. Claudia Mo. I'd like to ask a question that has to do with the general picture. There are 27 members on the HKADC, but only up to 10 members out of the 27 may be nominated by the specified groups and so on. So is that ratio too low? I mean, only up to 10. What were the considerations? I thought that at least half of the 27, say 13 members, should be able to be nominated.
Thank you. Now let me give you some background. Now we also took reference from other jurisdictions. Now, looking at bodies similar to our Arts Development Council, including New York, London, Singapore, and New Zealand. Now, the appointment of members is usually done by the government rather than nominated by those in the profession. Now, we also look at the background. Now, going back to 1995, when we enacted the legislation, there was a lot of discussion and exchange of views. So the background was that this is the fruit of rather detailed discussion. Yes, my question is why was the figure arrived at 10 rather than 14 or any other number? Now, there were 9 arts interests, one from each sector, so there were 9. And then in 1999, we had Chinese opera or Siqu added, so we now have 10. Now, apart from these nominations, now the appointed members of ADC includes quite a few from the arts sectors. So people coming from the arts sector within the ADC exceeds the 10 suggested here. Now, okay, Mr. Wu. Now, we are now suggesting, now extending the cross-sector arrangement. Now, I support it. Now, we were told that the appointment system is also done in other jurisdictions. And, well, even if it's properly elected, after these, you still need to have the government's appointment. Now, in your discussion so far, have you considered a kind of extending the number of cross-nominations? Because in my experience in this field, quite a lot of those of us are of the view that this cross-nomination should be expanded so that the arts interests can be better represented in the council. Now, the paper is silent on this. So apart from what you have said, because of what the law has stated, have you considered increasing the number even further? Now, so your question, Mr. Wu, is whether we can now have more than 10. So it's similar to Ms. Mo's question, why is it not 13? Why is it not half? Is that right? Okay, Ms. Lai. Now, the work of the ADC involves promotion, planning, and launching of policies. And so in its implementation of its work, you have to remember that people from other professions also make very useful contributions to the council. So at the moment, we don't have the plan to look at the composition or to review its composition, but we have heard your views. So when the time comes for reviewing the composition, we will take these on board. Now, we have no intention to suggest that other appointed professionals are not playing their part or have no contributions. But have you considered, while undertaking this exercise, consider increasing the number of cross-nominations? Has that ever crossed your mind? Ms. Lai. Now, in our legislation, we specified the 10 arts interests and 1 member from each sector. And apart from that, there are other members also coming from the arts background. And some of them are very experienced. They may not come out to compete for any seats, but we appoint them into the ADC, and they make positive contributions. And we are of the view that the present composition is balanced, is appropriate, and suitable. But when we review the composition again sometime in the future, we will take on board member suggestions. So you are not doing that right now? No. Now, do you have a timetable? Well, not at the moment. That's her answer. So, okay, so your question is, when are you going to do the review? Now, we have one nomination exercise once every 3 years. So every time before we do this, we will do a review and then decide what the next exercise will entail. Okay, so I hope you will take on board our views. Mr. Ma. Now, I'd like to ask about paragraph 6. Now, well, you are expanding the representatives without corresponding changes. Now, but paragraph 7 suggests that the cross-arts system is not really meeting what the law is suggesting. Now, I'd like to declare interest that I've been chairman for 6 years, but I was never told that what I have done may not really be entirely appropriate. Now, this is my question. Now, if we don't have the time to pass this, or if this is not passed, but now we have a nomination exercise, and if we fail to pass or to pass the bill in time, how will this impact on the nomination exercise currently underway? Now, because the voter registration is ongoing already, so do you think we can pass the bill in time? And how will the nomination exercise be affected if we cannot do it in time? And will the results which come out be recognized? Ms. Lai. Now, we have consulted the DOJ for legal advice. So, while scrutinizing the bill, we are going to resort to administrative measures to do the nomination until a time when the bill is passed. Once passed, we will gazette the bill and notify all parties. And when it comes to appointment, it will be done as in the past. The CE will resort to 3.3a, Section 3.3a, for the appointment, similar to past practice. So this is the view of the DOJ, and we intend to follow that. Okay, now if that's the case, whether or not we pass the bill will have no effect on the nomination. Am I right? Now, of course, the better arrangement is for the bill to pass, and then we can rely on Gazetto to implement Section 3.4 and Section 3.5. But when it comes to the actual appointment, we will have to rely on Section 3.3a, as in the past. So the important thing is to follow Section 3.3a. Yes, that's for appointment. For other nominations, it will be the other two. Now, in the past, all appointments were done according to 3.3a. So what is the purpose of this current exercise we are doing? Because you can solve the problem by doing 3.3a anyway. Now, if there are wordings related to the nomination exercise, we think that we should be able to follow the statements. Now, maybe my learned colleague here can supplement. Yes, this is very important. Okay, so can I resort to or defer to Ms. Betty Cheung? So, now, before we pass the bill, or while we are scrutinizing it, we may or may not pass it at the end. So what will happen? So I think that's Mr. Ma's concern, Ms. Cheung. Yes, can you speak closer to the microphone, please? Now, I think as Ms. Lai was saying, now the ADC member's appointment is done according to Section 3.3a. And at the moment, Section 3.3.4 and 3.34 and 3.5 also specify that certain groups can undertake nominations. So this is what the law provides for, and the CE can appoint these specified members as ADC members. The bill, I beg your pardon, the current legislation is that there is inconsistency in two aspects. Number one, the specified persons are not necessarily individual workers, and that the specified members, when they are nominated, they may not be cross-arts interests nominations. So we want the wording of the bill to comply with or to tally with the actual procedures. Now, I think Mr. Ma's question is, now before the passage of the bill, are you going to do it using the old way or the new way, assuming that the bill will be passed? Now, I know that at the end of the day, the CE will appoint according to the power conferred on him. But before that is done, you are using administrative measures. Now, if there is no passage of the bill and you have appointed certain individuals, so what would happen after that? And will the CE appoint those individuals? So that's something to be sorted out. Ms. Cheung. Now, on these individual arts workers, now there are two stages here. Now, first of all, the CE via the Gazette will specify a group of people, and these groups of people will nominate a maximum of 10 for the CE to consider whether to appoint or not. So there are two stages. First of all, the nomination or specification, and then the appointment. Now, during the first stage, now, the current law is that it specifies only groups or organizations. And we are proposing that individuals can also be specified or nominated, or to be nominated, that they become eligible, and then finally to be appointed by the CE. So,
well, my understanding is, as the DS puts it just now, in the past, individual art workers had been specified to take part in the nomination exercise, and that reflected the views of the sector. Thank you, Chairman. Deputy Secretary, anything to supplement? Well, in Section 3.3a, the appointment is to be made by the Chief Executive. Section 3.4 stipulates that the Chief Executive may consider the representatives nominated by the sector before making the appointment, but ultimately the power to make appointments comes from Section 3.3a. So in accordance with past practice, we have started the nomination exercise for 2013, and once administrative arrangements for this nomination exercise is completed, the Chief Executive will appoint members according to 3.3a. But the difference between this nomination exercise and the previous ones is that in the past, after the registration of arts organizations or individual art workers have been completed, these organizations or arts workers would be published by notice in the Gazette, and this is in accordance with Section 3.5 in relation to the gazettal process, because Section 3.5 states that this can be done by notice in the Gazette. And this year, before passing of the bill, we won't go through the gazettal process in publishing the list of organizations and individuals. Rather, we will rely on administrative arrangements. That's the existing practice, and after the passing of the bill, we will publish the list by notice in the Gazette. Dr. Ann Chang. Thank you, Chairman. 2 questions. First, in relation to the 17 appointed members, how many of them come from the sector and how many of them are outside the sector? And for these appointed members, how do the nominations reach the Chief Executive for consideration for appointment? Now, for the composition of HKDC, it comprises chairman and a vice chairman, and normally up to 10 members will be nominated by the sector, and 11 remaining members will be appointed by the Chief Executive. There will also be 3 official members, including the representative of the Secretary for Home Affairs, and also 1 representing the Secretary for Education, and the other representing the Director of LCS. Now, for nominations from the sector, normally up to 10 may be nominated, but that depends on whether we have 10 candidates from the sector in the nomination exercise. As for the remaining 11 candidates, 4 or 5 of them actually are experienced members in the arts sector as well. So out of the 27 members, over half of them come from the arts sector. Yes, Dr. Chang. A follow-up question. You just said that for members appointed by the Chief Executive, close to half of the membership comes from the sector. The remaining comes from outside the sector. So I'd like to know how the nominations are done for appointment by the Chief Executive, inside or outside the sector. Is it on recommendation of the Chairman or the Administration, Deputy Secretary? Well, the practice is the same as membership for other advisory bodies and committees. Recommendations will be made by the sector to the Chief Executive for consideration of appointment. Dr. Helena Wong. My question is, some members are so-called nominated by the Chief Executive, some others are nominated by the sector. So what is the ratio in relation to members coming from the arts sector? Do you have an actual figure, including the chairman?
就喺現屆係咪？現屆。
I'm talking about this term. Oh, we need to count the number. So this is just a ballpark figure. We have 16 members out of 27. So 16 out of 27. Oh, this year the membership, the maximum number of members can be 27, but this year only 25 members have been appointed. So out of 25, 16 of them comes from the arts sector. I'm sorry, perhaps because I was late, I didn't catch it quite clearly. What are the criteria for appointment by the Chief Executive? In fact, all 25 members are appointed by the Chief Executive, but 10 appointed members actually have been nominated by the sector through an election exercise. What about other appointed members? For other appointed members, we recruit talents from other sectors like the legal sector and other members who have been, say, supporting the arts sector, for example, in terms of sponsorship or promotion, or, for example, in schools. These members have been very committed in promoting arts. So, these talents from various sectors may be considered for appointment to the HKADC as members. Well, Dr. N. Chen just asked a question, but I didn't catch the answer very clearly. So, for the other members who are not from the arts sector appointed by the chief executive, now you say that some are from the legal sector, some are from other sectors, and I'm asking about the criteria, and you haven't made it clear, because the objective of the HKADC is to promote the development of arts. So what are your considerations? How can they help to promote arts development? What is the mechanism? Well, is it just that some names pop up in the minds of the chief executive for the appointment, or can recommendations be made by the sector, or do they recommend themselves? Deputy Secretary. Well, I explained just now that for members appointed as members of the ADC, other than those being nominated for appointment, well, it's similar to the practice for membership of other advisory bodies. The relevant policy bureau will make recommendations, and in doing so, the policy bureaus do consider the qualifications, experience, and their past contribution to the promotion of arts in Hong Kong in considering the appointments or recommendations. Now, I said that this year we have 25 appointed members. Apart from the official members, 22 members actually from the arts sector. Dr. Kenneth Chen. I want to explain that I just come up from the Public Complaints Office, so I'm late. I'd like to follow up on Mr. Ma Fung Kwok's question. I do have a concern because this is the Legislative Council. We need to scrutinize amendment bills. This is a solemn procedure. So Mr. Ma Fung Kwok's question is a very important one. For the next term of HKADC and the next nomination exercise, up to 10 may be nominated, and we need to set down a schedule for seeking views. I understand the purpose of this amendment bill is to narrow the law, the gap between the law and the reality, to do away with the inconsistency. So the question is, as Mr. Ma Fung Kwok puts it, no matter when we pass the bill, it won't be able to make it in time as far as the nomination exercise is concerned. So if you look at one single provision, it's indeed the chief executive does have the power to make appointments. I'm talking about the 10 members who may be nominated by the sector. Well, right now it's done by the administrative arrangements. Does that mean that there no legal basis is necessary for the administrative arrangement? If the answer is no, then why does the administration go ahead with it? And another question arising is, will this be subject to judicial challenge? Will, in relation to decisions made in the process, I mean, will it be subject to challenge? Has the administration considered that? And a more general issue, well, as mentioned by others, members at the panel meetings, why is it that for individual art workers who have certain qualifications overseas and for full-time students in the arts program, you do not have planned to have them included in the nomination exercise. But perhaps in the scrutinizing the bill, in the process, we might accept this approach so that the base would be widened. And yet you have not considered to change the administrative arrangement, and there will be a consistency. There will be inconsistency. So can you tell us something more concrete? I want to do this properly. I don't want us to just muddle through because of all these gray areas. Deputy Secretary. Now, about this exercise in 2013, just now, myself and my colleague from the DFJ already explained the approach for this year's nomination exercise. Now, whilst this bill is being scrutinized, we will implement an administrative arrangement for this nomination exercise. And what is the difference this time? The major difference is whether these organizations or arts workers are specified by notice in the Gazette for taking part in the nomination exercise. As for other phases of the exercise, we will everything will be the same. So, Deputy Secretary, I think we're not very clear. We're talking about where the power comes from under this arrangement or administrative arrangement. I think we have discussed this issue during the last term, and there are new members here who might not be very familiar with it. So can you explain once again how administrative arrangements can be implemented to achieve this purpose? I will invite my colleague from DOJ to explain about the legal basis. Thank you. Now, in the ordinance, in fact, sections 3, subsection 3, 4, and 5 provides that the chief executive may, by way of notice in the Gazette, specify organizations or groups of organizations for appointment by the chief executive, but the provision only stipulates the practice to this extent. There is no impact on Section 3.3a in relation to the power of the chief executive to appoint members. So these two are not mutually exclusive. That means the chief executive does have power to appoint members. I'd like to remind members of the question raised by the legal advisor in the Legislative Council. Well, he asked whether the validity would be affected, and we replied that in relation to Section 51B of the IGCO, it states that where any board, tribunal, commission, etc. is established by or under any ordinance, the powers of such bodies shall not be affected by any defect in the appointment of a person purporting to be a member thereof. So on this basis, members of the HKADC, in terms of previous appointments, even if the appointments had any defect, it would not affect the validity of the powers of the HKDC.
Now, before I ask our legal advisor to speak, now, let's come back to the crux of the matter. Now, what is the main reason for the present exercise? Now, our legal advisor. Now we are talking about 3, 4, 3, 5. They're talking about two different things. Now, the first one is that for those groups, organizations, they can nominate not more than one person. The restriction is that you can only nominate one person for your own arts interest area rather than cross arts interest nomination. And 3.5 says that the CE can, via the Gazette, specify 10 organizations and not individuals. So since 1997 or 1999, the practice does not really fit the two sections. So the current exercise is a kind of a remedial measure. Now, if members' concern is that if there is delay or not passing the bill, now what will the result be? Is not really something that can be remedied by administrative measures. You cannot circumvent that because the specified group is limited to groups rather than individuals. Now, if the administrative measure involves individuals, that will be contravening 3 subsection 5. And when it comes to voting, according to 3.4, you can only vote for your own arts interest group and not cross section or cross interest. And if you pursue cross arts interest nomination, this can lead to challenge later on. Of course, the CE can appoint people, but if the appointed people is not specified according to the law, this can be subject to challenge because that will be against procedural propriety. So it's liable to challenge later on. Now, if the past appointments are not entirely appropriate, now, will the people so appointed and the work be affected? Now, the government's response is no, but the IGCO is really Section 51, not Section 15. And I'm not going to repeat what has been read out. Now, I agree that this can protect the work of the past members because based on Chapter 1, Section 51, the work will be protected. And the work of the ADC is not affected. This I can accept. I am not objecting that he has the right to appoint, but that does not mean that the appointment cannot be subject to challenge. So this passage of the bill is important. And if it's not passed, then you should really be following the law. Now, I'd like to thank the LA. Now, and all the past work can be cleared based on the IGCO. So Mr. Ma's worry can be allayed. Now, but looking forward, we have to understand very clearly, rather than trying to muddle through by means of administrative measures. I do not want future generations to look back and say that, well, why we are muddling through things, and that the appointment or the nomination is not legal. Now, I would like the administration to think through this more carefully. Can you really circumvent legal requirements simply by administrative measures? Now, our LA is of the view that this should not be done. So let's try to rationalize things. Now, can I ask the government to respond, please? Now, our DOJ colleague has pointed out in detail our legal standpoint. Now, we agree with members that if the bill can be passed quickly, the whole arrangement will be better. Now, it seems that we have two different legal points of view here. Now, I think that passing of the bill will help. It will help to clarify things and will make things more appropriate. And if there is no passage of the bill, and if we continue with the nomination and appointment, this may or may not give rise to challenges. So let's perhaps look at what is in front of us for the time being. Now, thank you, Chair. Now, in the past, there were 9 arts interest areas. Now we have 10. Maybe in the future, there will be an additional one. Now, if that's the case, what is the procedure for doing that? The DS. Now, every time when we prepare for the next round of nomination, we will do a very detailed review with the ADC. Now, this time round, they have a special group created, and then they consulted the 10 arts interest areas as well as public consultation. And then the ADC, after detailed consideration, will give the government a proposal. Now, if we have the next round of nomination, we will first of all do review and then consulting the public as well as the sector. And we aim to arrive at a consensus, and then if necessary, there will be a legal amendments. Now, here, the follow-up is that, okay, after consultation, will there be some sort of a ceiling or cap? Now, we have to look at the overall ratio or proportion as to whether arts interest areas needs to be added. Now, I think this will require a very detailed discussion as well as a consensus. So there's no capping as long as there is consensus. Now, I think we have to look at the overall composition of the council. I think we should look at it holistically. Now, because the maximum, well, now at the moment there are the cap is 27, and now you have 2 vacancies. But what if the consensus is that there should be 3 more arts interest groups? So what are you going to do? To remove 1 government representative, or what? So, will there be any cap on the arts interest group number? We are not doing this kind of review at the moment. So at the moment, I cannot tell you whether the overall figure will change. Now, I think that is just another way of asking the same question. It was asked earlier by 2 different members already, whether the number of such representatives can increase. Anything else from you? Now, if it involves nominating, now the 27 is the legal cap, right? And is there a cap for the arts groups representatives? This will have an impact on the number of the other category members. Yes, Mr. Wu, all the 10 are specified by the sector. But then with consensus, the number can increase. Now, the DS, now, the 10 areas are specified in the law. Now, if after consultation and review, there are going to be changes, then the law has to be amended accordingly. Yes, so 10 is at the moment the legal number. So there is no such thing about any consensus. No, the point was that there could be review, but at the moment they are not doing such reviews. Now the other question is, okay, now you have the 10 areas, and what if there is no representative from that sector? So what is going to happen to that vacancy? Now this happened in the last time round. Now of the 10 sectors, in the arts criticism area, there was no representative. So the CE appointed one person based on Section 33A. And if, let's say, you have 2 terms of no one coming up representing the group, then will that group be taken away? Well, so that would be, again, for the ADC to discuss and decide. I think Mr. Ma started a very interesting question. Now, we have to look at it more seriously. What might first appear to be a very simple exercise. Now, since 1999, and, you know, after hearing our legal advisor, which I fully agree, you are trying to remedy something which has been going wrong since 1999. Now, I asked some people, but they were quite confused and did not really know what to do. Now, of course, I'm not targeting the DS, but the question is that for the last 10 odd years, you have been doing something which is not entirely appropriate, and you are doing a remedy, you know, after this very, very long time, and you are resorting to administrative measures. Now, you are not talking about the appointment thing. You are talking about the nomination. Now, in fact, all 25, 27 are appointed. Yes, you are right, Mr. Chairman. Now, I think we have to be very careful. Now, the 10 members, I don't quite follow you. Because since 1999, all these 10 individual workers, they are now sitting on the council not based on proper nomination procedures. You don't have to make life difficult for her. She is now trying to remedy the situation. Now, I like to explain the situation. Now, when the law was enacted in 1995, it was specified that only groups or organizations can be specified. But now, there was but after that, there was strong concern that individual workers should be able to take part. Now, because of the request from the sector, we have added in the individual workers category. This is something that the sector wants to have. And in 1999, the sector also wanted to have a cross-sector nomination or cross-arts interest nomination. And they think that this is more appropriate and will allow the voters or the candidates to have a more holistic picture, all-rounded concern of the art sector. So after 1999, we were allowing this to take place.
Chen Yuhan's question is that since 1995, after passing the law, only organizations could be specified. But after 1999, in the process, there were strong views from the sector for individual art workers to be nominated as well. And thereby, we had 10 up to 10 members could be nominated. Now we have the problem of individual arts workers. Is it against the law? Is that your question, Ms. Chen? But this is happening now. That's why I say that we're not acting in accordance with the laws and the rules. Every parliament has its own rules. We have the rules of procedure, so we act in accordance with the law. All right, it's a good thing you heeded the views of the art sector. You allow individual art workers to be nominated. But what I'm saying is that you didn't amend the law until now. So the view of the DOJ is that it's not against the law, but what did you say, legal advisor? Thank you, Chairman. Now, the Department of Justice explanation, in accordance with Section 51B, is that it's inconsistent with the law. All right, so that means we need to amend the law to do away with the inconsistency. All right, I get it. So my question then is, we're talking about 10 members, and well, she did mention it, where there was no nomination, the chief executive could make the appointment. So I don't know what is going to happen in the future. Well, although they say it can be done, but Chairman, it's just like at the Finance Committee, we must resolve the problems, but this cannot be done immediately. We need to act in accordance with the rules of procedure. So when we see this bill, I think originally it seems a very simple bill, but I think we need more meetings in order to protect our council, or we will be accused of dereliction of duty, because we already see this situation happening. We need to receive deputations and express our views to them and see what they think. Well, dereliction of duty, well, I think we need to make things clear. The administration is responsible for drafting the bill. But what if we pass a bill? In the past, in 1995, after this ordinance was enacted, at first there was no nomination exercise by the sector, but because of strong views from the sector, ultimately they were allowed to do so, and yet the law hasn't been amended. At the panel on Home Affairs, even during the last term, I already discovered this problem. I asked the administration to review the law to remove the inconsistency. That is why we have this bill. Well, Chairman, please stay calm. This is exactly why I say we need to be careful in scrutinizing the bill. We need to check each and every detail. You know that I wasn't in this council during the last term, and thank you for raising this question last term. I'm saying that we need to be careful about the details. I really think that we were fooled. Well, I'm also an experienced lawmaker, and I think that at this point I need to be very careful. Although in the past on other occasions I could trust the administration. Well, of course we need to be careful. I mean, the administration should respect the Legislative Council as well. They should not accuse us of challenging the government. Ms. Claudia Mo. Well, creation online. Well, some call this business, some call this arts. Well, you have 10 arts interests. Can it be regarded as visual arts? But for online creations, well, you have sound as well as pictures. So can you call this visual arts? Or can online creation be regarded as any of the 10 arts interests? And if we are to hold a public hearing, many deputations will be asking for a new interest area to be created, and that's online creation. So that's what Mr. Ma Fung Kwok's question referred to. What if the bill cannot be passed? Will that be a big problem? In the 10 arts interests, we do have visual arts, and visual arts can take many forms and be presented via many media. So, to answer me directly, can online arts creation be regarded as any of the 10 arts interests? Multimedia production, yes, it's included. To which arts interests it belongs? It depends on the arts form. I'm talking about online, internet. Well, internet, say if you have a musical performance, it will be regarded as music. So it really depends on what kind of art form it is. Can I take it that your answer is that for online arts creation, it can be regarded as any of the 10 arts interests? Deputy Secretary, if it meets our criteria, then of course, what criteria are they? In January, when we briefed the panel on Home Affairs, we reported in detail to the panel the criteria for individual art workers, and it encompasses a wide scope. Well, please let her finish. Yes. Individual art workers. There are 10 categories of individual arts workers. For example, if the individual had been a consultant or a member of the HKADC, or since the establishment of the HKADC, the individual had received any award or been shortlisted in any art exhibitions or competitions held by the LCSD, or as an individual, the person had been awardees or grantees of the HK, CD, LCSD, etc., or had received grants from LCSD to take part in exhibitions, competitions, etc., or have engaged himself in arts administration, or have collaborated with the LCSD in holding arts exhibitions or competitions, or have participated in these programs. Well, I think, yes, the list goes on, but I think that's all we need. So, in short, you talk about the eligibility criteria. So, do they include online creation? Yes. If it falls, or if it meets the criteria for any of the 10 arts interests, then yes, Dr. Helena Wong. I think some members already mentioned this point. In this legislative amendment exercise, is there room to increase the nomination quota for the 10 arts interests? I asked the sector why nominations had not been made for some of the arts interests, and they told me that since there were only 10, they didn't bother to register themselves. So, is there room to increase the number of nomination quotas? Yes. On expanding the arts interests, well, we need to fully consult the sector before making this decision. We have no plan to review this arrangement, but in future we may consider it. Dr. Helena Wong. Well, we need to consult and receive deputations anyway. So why don't you do it in one go? Of course, I get in touch with just a limited number of individuals in the sector. But if we have a public hearing, we will be receiving representatives from the arts sector. So why don't you do it in one go? Our time is valuable as well. It's just a very minor issue. You can improve this in one go for the sake of future development. I oppose you doing things in drips and drabs, and in a year's time you come back and you say you need to consult again. You're wasting the administration's time as well as the LegCo's time. So my suggestion is for you to review the arrangement concerning the 10 arts interest areas. Yes, the HKADC conducted the review last year, and there was a public consultation, and recommendations were put forward after heeding the views of the sector. And in January this year, we briefed members of the panel on Home Affairs. After making this general report, in March, the consultation exercise commenced. Individual arts workers have already registered themselves with the HKDC in phase 1, and in fact the deadline has been passed, and we're now vetting the applications. And there are 4 phases to this exercise, and it takes roughly half a year's time, and we have actually completed the first phase of the exercise. In January, when we reported to members, we briefed members on the arrangement, and we are acting in accordance with that arrangement. We are vetting the applications. Dr. Wong? No? No, nothing further? Yes, Ms. Chen Yunhan. Chairman. Well, it immediately occurred to me that about the URA, the administration changed from a white bill to a blue bill. So it seems that the administration, after listening to us, will save the further amendments to later. And I agree with Dr. Leonard Wong that this is not just about principles. We need to heed the development of the sector. If there are new art forms, it may not be covered in the ordinance. So why is the administration insisting on finishing this part first? I agree that the consultation was done last year, but the sector is developing. Now that we have views, I just want to suggest to DS that you should consider it. Well, there's a long title in the bill. For any amendment bill, we have this long title. If you want to go outside the scope of the long title, that's another matter. I asked Deputy Secretary whether you will consider changing the 10 arts interests. Will any change be done? Yes. The HKADC conducted a review and the public consultation exercise last year. It took much time, and after briefing the LegCo panel this year, we already started the nomination exercise. The first phase of the exercise has actually been completed, and we are acting in accordance with the arrangements which we reported to LegCo members, and members of the sector have already made nominations, and the exercise has commenced. It's ongoing, so if we are to conduct any review, we will do it or we'll consider it later.
Chair. Now, okay, you have 10 or what the 10 would include. Now we can have a framework and stipulate when or how the government can increase or decrease the number, rather than having to go through changes of the bill every time. So can the government go back and use some sort of a framework. And rather than using a very rigid number, 10. Okay, now maybe we can leave it to the panel that Mr. Ma chairs, because the present bill does not really cover this point about the number of such arts interest groups. Now, if the amendment exceeds the scope of the bill, it may not be passed by the electrical chairman. Now, I understand that the Bureau is helping to do the nomination, and you have a voter nomination starting in March. But let's look at the time frame for looking at the bill. Now, give us some information or more information. What is your overall plan? Now, I've asked a question not necessarily about the number 10, but the size of the electorate. Now, it's still possible to discuss this when we are talking about individual arts workers. So who are those individuals? Now, what is your overall scheme? Now, when are you going to gazette? And then when will the election results come up? So give us a roadmap or a time frame. Now, there are 4 stages. First of all, there will be groups and organizations, or those who are eligible individual arts workers. They will make an application. So that will be stage 1. So using our past experience, we are using the 15th, starting from the 15th of March until the 25th of April. Now, and then for the individual arts workers, we have reported to the panel in January about the 10 groups. Now, the application period, again, we have passed the deadline. We are now doing the scrutinizing work. Now, the next stage will be the voter registration. If it's individual workers, and if their qualification has been ascertained, then they do not have to come again for stage 2. Now, so stage 2 would be the eligible organizations with workers belonging to this category. Then they would do the registration under stage 2. Now, our time frame is that the 7th of June until the 15th of July, that will be voter registration. And then from the 26th of July, or towards the late July, we will start the nomination, because they have all been registered, and if they want to have nomination, they will have to start the application by late July. And this will take us to August, and they would do the proper campaign, preparing their platform, and so on. And by mid-September, voting will take place. So that's our timetable. Mr. Chan, any follow-up? No, not at the moment. But let's keep an eye on this timetable and see if there's any room for negotiation. And I think our colleagues are very experienced, but I'm still very, very worried. We want to rationalize things. But is there anything we can do at all to help with the nomination and the election to make it more acceptable? So we would like to contribute to this to make the exercise more easily acceptable by everyone. Mr. Ma. Now, I would like to ask another question. Now, I represent the sports and the performance sectors. Now, I'd like to look at the various subgroups, their voter registration qualification or eligibility. They would have to follow Cap 472 and then Section 3, subsection 5, and to follow 3.4. Now, these are the specified groups and organizations. Now, if after passing of the bill, now the newly registered voters or the gazetted voters, will they be able to migrate to the voters in the corresponding categories? Now, can the government clarify this point? Now, the DS. Now, based on the legislative provision, now all the gazetted personnel under their respective sports performance sectors, etc. Now, after the passage of the bill and after gazettal, these various groups will become the Legislative Council functional constituency voters. Now, in the past, you only had groups and organizations, but now you have groups, organizations, and individual members. So Section 3.4 or 3.5 will include the individuals. So this will be done in the gazettal. So under the election ordinance, which specifies 3.4 and 3.5, it specifies organizations. But then what about the individuals? Now, the electrical FC elections will follow the electrical election provisions. It will have organizations, and those will be the electors, and the individuals will not be so, because at the moment the provision is that under the gazettal they will become the electrical FC electors. Mr. Chan Ka-lok, now when we are dealing with the District Council amendment, a similar question was raised. And can we also ask the government to prepare a paper? What will be the corresponding changes or effects? Or basically following Mr. Ma's question. Now, I think we have to go wider than that. I think it's something the government can do that. Relevant provisions. Would there be any corresponding changes needed? Now, anything which is related to what we are scrutinizing. Okay. Any consequential amendments, in other words. We will prepare a paper to this effect, yes. Ms. Chan, I welcome the DS reaction. It's a very important point raised by Mr. Ma. It cannot just be following the election, but you have accepted the responsibility and you have adopted a very open attitude, so I have no further question. And your response was appreciated. Any other views?
有冇？
你開啟啲主席。
係。
我仍然想返去講。
Chair, now, coming back to the point about the 10 groups or members. Now, as of today, under the ADC, now there are new art forms coming up, and the government should take this on board. And I hope the government can deal with this time. So related to Mr. Ma's second question, so don't reject us right away. So you are saying that this is not in contradiction to the long title. Now, regarding the 10 nominees or the 10 groups, now, can we make any changes now possible? Now, is my interpretation correct? Now, can you please respond, the LA? Now, the members' suggestion is whether at the same time we can consider amending the various specifications of the 10 groups. If you look at the long title, is to amend the under sections 3, 4, and 5 of the ordinance, organization or groups of organizations may be specified by the CE for the purpose of nominating persons for appointments as members of the HKADC. Now, this is pretty narrow, and if you amend the 10 groups, it will involve the formation of those groups, the composition, as well as the electoral base. Now, and that exercise may not really be able to come under this particular long title. Now, they have a maximum of 27. So can we change the figure of the 10 that we've been discussing? Now, the composition is a very big issue. Now, if the government is not trying to amend the composition, so it may exceed this particular scope. Anything from the DS? Now, I think I have already given a very detailed response on the 10 groups. Okay. Now, I don't see any further questions from members. Now, that being the case, now we have fixed a time that's on the 13th of June. We're going to have a public hearing. So let's listen to them first and take it from there. Now, the clause-by-clause scrutiny will be very simple. So let's have the public hearing first. And we have quite an in-depth discussion today. So let's maybe we will have the next hearing first. Okay, the 13th of June. It's a public hearing. And then we will decide what to do next. Or shall we decide on the fixed time again? Now, the 13th of June, we're going to have the public hearing at 8:30 in the morning. And after that, the 18th, okay, this is the next meeting after the public hearing would be 2:30, the 18th of June.
18th of June, Tuesday, 2:30. That's for the next meeting. Can we have the meeting in the morning? Who's unavailable? What day of the week is that? Tuesday, 2:30 p.m. Well, Chairman, basically I won't be available because this is the day for the District Council's meeting. If not, then 21st of June, Friday in the morning, 8:30. How about that? All right. No. We need to discuss the hawkers policy. All right. What about 13th? 13th, that's the date for public hearing. So another meeting will be arranged after the public hearing. Yes, another meeting. Well, we need to find another time slot. What about Monday, 24th? 24th, Monday, 10:45. We have EDP. How about 9? How about 9? We need to look at the venue as well. We're looking at the 24th of June, 10:45. See if this slot is okay. Is okay with me? Then okay, I won't go to the other meeting. I have a meeting on Monday morning, but I will skip that. So 24th of June, 10:45 a.m. to 12:45. But we'll have a panel on development. No, it's economic development. But cultural development is also important. We definitely will clash with some meeting anyway. All right, so that will be it, the 24th. You can attend both meetings. So meeting's adjourned.